I'm told that we may be going to votes in a minute. So if that's the case, I think what we'll do is just not begin and postpone this till tomorrow. No, I'm just kidding. And we'll start immediately after votes. Good morning again. Or now, I'm sorry, it's late mid-afternoon. So the Subcommittee on Capital Markets and Government-Sponsored Enterprises will now come to order. And today's hearing is entitled Legislative Proposals to Enhance Capital Formation, Transparency, and Regulatory Accountability. And without objection, the Chair is authorized to declare a recess. Hopefully we won't need another one for votes of the subcommittee at any time. Thank the panel for their patience. I will begin. I now recognize myself for 2 minutes for a opening statement. Today, the subcommittee meets to examine 3 important pieces of draft legislation that continue to work over the last 5 years to modernize our nation's securities laws and promote transparency and competition in our capital markets, and basically to bring real reform and accountability to the SEC's rulemaking process. A recent poll indicates that about 2/3 of Americans believe our country is headed in the wrong direction, and a declining number of people believe that their children will be better off financially than they have been. So, despite the big promises that have come with granting vast, in some cases unlimited authority to the federal bureaucracy in D.C., most Americans aren't buying the argument that a bigger Washington leads to a bigger paycheck at home, or even any paycheck at all. Fortunately, our subcommittee has for 5 years now tried an alternative approach which seeks to do what? To empower entrepreneurs and investors and small businesses, but not the bureaucrats. This approach has led to some successes, most notably the Jobs Act of 2012. But maybe more important than that, has led Congress and the regulators to think in a different way than they have historically. So today we continue our important work with 3 pieces of legislation. First, we'll consider the SEC Regulatory Accountability Act. And it would require the SEC to determine that the benefits of any regulations they're considering actually outweigh its cost. Even President Obama, through Executive Order 2011, has recognized the importance of economic analysis in rulemaking, and this legislation would codify much of what the President's Executive Order did for the SEC. Secondly, we have the Investment Advisors Modernization Act, with Mr. Hurt sponsoring it. This is a long overdue piece of legislation that would allow private capital to continue to play a critical role in our economy, at which reduces many of the unnecessary bureaucratic requirements that have led to the effect of starving middle market businesses of the capital they need. Thirdly and finally, Mr. Duffy has put forward a Proxy Advisors Reform Act of 2016, which would, for the first time in memory, provide some much-needed sunlight to the way in which proxy advisor firms develop and distribute their advice. So, this subcommittee has led the charge in Congress for reform of the proxy advisor industry, and this draft legislation is the next step. So with that being said, I want to thank all of the sponsors here for their hard work on all of these bills, and I look forward to our witnesses today. And with that, I yield the gentlelady, hello, from New York, 5 minutes.
Thank you, and I thank the chairman for holding this important hearing and for all of our panelists to being here today. We're considering 3 bills, all of which deal with different issues. First, Mr. Duffy and Mr. Carney have a bill that would establish a regulatory regime for proxy advisors. Proxy advisors provide recommendations to institutional investors on how to vote on board of director elections and shareholder resolutions. Big institutional investors are shareholders at thousands of public companies, and they simply don't have the time to carefully review every single 100-page proxy statement in detail, especially because most public companies hold their shareholder meetings in the same 3-month period. So institutional investors rely on proxy advisors for vote recommendations, which are often tailored to the investor's particular corporate governance preference. This is healthy. Proxy advisors do have the time to carefully read all of the statements and proposals because they have professionals who simply read these statements all day, every day. However, this means that proxy advisors can be very influential in the outcomes of shareholder votes, although the evidence on the influence of proxy advisors is mixed. It is probably fair to say that the current regulatory regime for proxy advisors is not ideal. 2 advisory firms account for 97% of the market, ISS and Glass Lewis, but for some reason they are regulated differently. ISS is a registered investment advisor, while Glass Lewis is not. Surely this is not an ideal setup, so I am absolutely open to the idea of a better and more consistent regulatory regime for proxy advisors. But there are several things in this bill that concern me. I don't see why companies should have a statutory right to receive and comment on a proxy advisor's draft recommendations before they are sent to investors. Proxy advisors aren't federal agencies, and a notice and comment period for private companies that are providing a valuable service, in my opinion, is not appropriate at all. I don't recall where this regulation is on any other private company. I'm also concerned about giving companies the right to sue proxy advisors just because they didn't get a meaningful chance to comment on draft recommendations. But I am willing to hear other perspectives on this issue because it is an important one that Congress has not examined for a long time. The second bill is intended to modernize the Investment Advisors Act for advisors to private equity firms and funds. This bill makes a series of targeted changes to the Advisors Act, which are intended to make it more compatible with the private equity business model. I think there is probably space to better tailor the Advisory Act to private equity advisors, but I'm concerned about making sweeping changes to core aspects of a regulatory regime that has been quite successful. We need to think very carefully before we make changes to the books and records rule, the custody rule, or the advertising rule. These are core aspects of the Advisors Act, and they shouldn't be discarded lightly. Finally, Chairman Garrett has an SEC cost-benefit bill. This is similar to a bill that this committee has considered before, but I am interested to hear if any of the witnesses can offer any fresh perspective on this issue. I'd like to thank our panelists for appearing before us today, and I'd like to insert a few statements into the record. These are statements from the Council of Institutional Investors, the Florida State Board of Administration, ISS, and Glass Lewis. And I hope that I'll be able to place these statements into the record.
Without objection, so ordered.
Thank you.
Gentlelady yield.
I yield back.
Gentlelady yields back. We now go to our Vice Chair for 1.5 minutes.
Thank you, Mr. Chairman. Thank you for holding this hearing today. I think every member of this committee can agree that with millions of Americans out of work, our top focus in Congress should be enacting policies to help spur job creation throughout our country. As I travel across my district, Virginia's 5th District, I continue to hear hardworking Americans express concern about the current state of our economy and the economic uncertainty facing their children and their grandchildren. Today, we will discuss several legislative efforts that, if enacted, will encourage economic growth and job creation by reducing unnecessary regulatory burdens. In Virginia's 5th District, thousands of jobs would not exist without the investment from private equity. These critical investments allow our small businesses to innovate, expand their operations, and create the jobs that our communities desperately need. Over the past 3 Congresses, there has been a growing concern about the burden that Dodd-Frank unnecessarily places on advisors to private equity, while at the same time exempting advisors to similar investment funds. Over recent years, many of us have worked together in a bipartisan way to eliminate the registration requirements mandated by Dodd-Frank. Today, however, among the legislation we are considering is a discussion draft titled the Investment Advisors Modernization Act. This bill would not change the registration requirement that Dodd-Frank mandated, but rather would update the Investment Advisors Act of 1940, a 76-year-old law, to reflect the current business model of private equity. This bill would go a long way toward facilitating capital formation while maintaining our commitment to investor protection. I believe that it is incumbent upon Congress to look for common-sense solutions to problems caused by a regulatory structure, and I believe that this legislation is a pragmatic approach to addressing some of the concerns with the Investment Advisors Act. I look forward to the testimony of our witnesses, and I yield back the balance of my time. Thank you, Mr. Chairman.
I thank you, the sponsor, and I now would turn to the other sponsor. Mr. Duffy is recognized for remaining 1.5 minutes.
Thank you, Mr. Chairman, and thank you for holding today's hearing and giving me an opportunity to briefly discuss my bill to foster greater accountability, transparency, responsiveness, and competition in the proxy advisory firm industry. Increasingly, institutional investors rely on the analysis and recommendations of proxy advisor firms on key issues facing shareholders and public companies. As the share of institutional investor ownership has grown from roughly 46% in 1987 to over 75% today, the volume of proxy votes which investors are responsible for casting has grown into the billions. Just two proxy advisory firms control 97% of the market, and their writings, analysis, reports, and voting recommendations affect fundamental corporate transactions like mergers and acquisitions, the approval of corporate directors, and shareholder proposals. I've heard from many companies about their frustration with the methodologies used by proxy advisory firms, the inaccuracies and inconsistencies in the information they share with their clients, and most importantly, the concern for conflicts of interest. These are very powerful firms that have a huge influence in regard to corporate governance. In 2013, Mr. Chairman, you held a hearing and have been involved in this issue on the subcommittee and had respected witnesses recommend more oversight of the proxy advisory firm industry, which my bill now provides. So we look forward to the witnesses' testimony on this issue and the other bills. With that, Mr. Chairman, I yield back.
Thanks. The gentleman yields back. So welcome to the panel. We now look to you. Some of you have been here before many times. Others are new here. So just you will be given 5 minutes. Your entire written record will be part of the record. We ask you to summarize it now in 5 minutes. There should be lights in front of you to indicate green to speak, yellow with 1 minute warning, and then red to be done. Also, there's we often remind people there's somewhere in front of you also is the button to turn on your speaker. So with that, we will turn to, from Atomic Global Partners, former commissioner at the SEC, Mr. Gallagher, recognized for 5 minutes, and welcome to the panel.
Well, good afternoon, and thank you, Chairman Garrett, Ranking Member Maloney, and members of the committee for inviting me to testify today. My name is Dan Gallagher, and I am president of Potomac Global Partners. And from 2011 through 2015, I served as an SEC commissioner, and from 2006 until 2010, I served on the commission staff in various capacities, ultimately as deputy director of the Division of Trading and Markets. I'm testifying today in my own capacity. Let me begin by expressing my appreciation for the work this committee has done over the last 5.5 years on legislation to rationalize and remove regulatory obstacles standing in the way of small businesses, as well as your initiatives to enhance investor choice. During my time as a commissioner, this committee regularly challenged the Commission to satisfy its statutory mission to facilitate capital formation, whether through the legislative process or through constructive and insightful hearings and roundtables. In an era of unbridled, misguided regulation, this was truly a breath of fresh air, and I deeply appreciated the opportunity to have worked with many of you on both sides of the aisle on these important issues. Mr. Chairman, having spent 4 years as a commissioner focusing on Dodd-Frank Act rulemakings, it's particularly refreshing to testify today on 3 bills which I believe will help the SEC get back to the basic blocking and tackling responsibilities of securities regulation that advance the agency's core mission. First, Congressman Duffy's bill will bring much-needed transparency, oversight, and accountability to the proxy advisory industry. Due in large part to the unintended consequences of the SEC's own rules, proxy advisory firms now play an outsized role in the shareholder voting process, often to the detriment of public companies, investors, and the American system of corporate governance. Representative Duffy's legislation would help resolve many issues which apparently remain unresolved despite recent SEC staff guidance through a comprehensive registration and examination regime for proxy advisory firms. I applaud Representative Duffy for taking an incremental legislative approach that is similar in many important ways to the framework for the Credit Rating Agency Reform Act, which enjoyed bipartisan support and passed the Senate by unanimous consent. Second, Chairman Garrett's SEC Regulatory Accountability Act would promote and improve economic analysis at the SEC and make the agency even more accountable to the investing public. While the SEC has dramatically improved the economic analysis supporting its rules, there remains room for improvement. In particular, I believe that in certain mandated rulemakings, the SEC's lawyers have played an outsized role in interpreting congressional intent, thereby setting the ground rules by which the economists are expected to operate. The CEO pay ratio rulemaking is the best example of this. Finding benefits when Congress described none may help get a rule done, but it ensures that the economic analysis is not done right. This trend needs to stop before it becomes the loophole that devours the SEC's 2012 commitment to proper economic analysis. Ultimately, Chairman Garrett's bill will help ensure that economic analysis conducted by economists is firmly entrenched in every rulemaking the SEC conducts under the federal securities laws. And last, but certainly not least, Vice Chairman Hurt's Investors Advisors Modernization Act would preserve the registration regime for private fund advisors while at the same time removing or modernizing some of the more unnecessary and overly burdensome requirements in the Advisors Act that serve only to drive up the cost for funds and investors and hinder the efficient allocation of capital that helps businesses and jobs grow. Since the passage of Dodd-Frank, the SEC has devoted a significant amount of its limited resources towards overseeing and examining advisors to private funds, who primarily serve sophisticated investors such as pension funds and endowments. During this non-recovery recovery, to borrow Chairman Hensarling's words, and given that there are over 11,000 SEC-registered investment advisors and just hundreds of SEC staffers to examine them, the SEC should be focusing its attention less on funds serving sophisticated investors who are better able to fend for themselves, and more on making U.S. capital markets more efficient and competitive, promoting small business capital formation, and protecting mom-and-pop investors. Vice Chairman Hurt's sensible legislation will help the SEC do just that. Thank you again for the opportunity to testify today.
I thank you very much. Next, from the Center on Executive Compensation, Mr. Timothy Bartle. Welcome. You're recognized for 5 minutes.
Thanks, Mr. Chairman, and appreciate the opportunity to testify. Congresswoman Maloney, Vice Chairman Hurt, my name is Tim Bartle, and on behalf of the Center on Executive Compensation, I'm pleased to share our experience with proxy advisory firms and to testify in favor of the Proxy Advisory Firm Reform Act. As I think you know, the Center is a research and advocacy organization. We represent over 125 companies and the senior human resource officers of those companies across a broad spectrum, and we have daily interaction with those companies and therefore have firsthand knowledge of their experience with proxy advisory firms. You know, at the end of the day, companies seek accurate and fair assessment of their pay programs, and when you look at the fact that, as Congresswoman Maloney indicated, proxy advisory firms do perform a necessary function in the proxy advisory and the proxy voting regime, but unfortunately, the time frame and the lack of oversight leads to a check-the-box mentality that is really a poor fit for pay programs which are individualized, complex, and lengthy. And, you know, when you look at the influence the proxy advisory firms hold over the regime, I think it's important that we take a look at that as we look at Congressman Duffy's bill. As of May 13th, companies holding say-on-pay votes this year who received a negative ISS recommendation experienced a 31% reduction compared to the previous year for a mean support of somewhere around 61%. Those receiving a positive recommendation had an average results of 93%. A 2014 Center survey found that 74% of respondents indicated that they had changed or adopted a compensation plan, policy, or practice in the previous 3 years, primarily to meet a proxy advisory firm policy. And research that we cite in our testimony by Professor Larker, McCall, and Ormathabel suggested that the adoption in advance of a proxy advisory firm policy actually had a negative impact on shareholder value. Both Congresswoman Maloney and Mr. Chairman, you mentioned the impact of conflicts of interest, as did Congressman Duffy. And because proxy advisory firms are accorded significant deference in light of their independent status, the conflicts are a big deal and need to be addressed. ISS, the largest and most influential firm, consults with investor clients regarding shareholder proposals that the investors sponsor while at the same time making recommendations on those same proposals to other investor clients. This leads to the perception that ISS may favor such proposals in making recommendations. ISS also continues to make recommendations and provide analysis of proxy issues to be put to a shareholder vote on the research side of the operation, while providing consulting services to corporations whose policies and shareholder proposals they evaluate. And that's on the consulting side. The aggressive marketing from the consulting side has left impressions on several occasions that it is privy to the information or the decisions on the research side. And as an example, back in 2013, there was a company that was contacted by an ISS consulting representative after the company received a negative ISS recommendation and had a low say on pay vote, around 68%. In an email to the company, the representative said that she would provide the company with a better understanding of the reasons for ISS's negative vote recommendation and what to expect in terms of additional scrutiny from ISS's research side in the next year. After a call was set up, during the call, the representative indicated that the information provided by the consulting side was not available elsewhere, and that the success of companies that had engaged with the consulting side were over 90% because of its knowledge of the research side. And at the SEC roundtable, even Gary Rotellny, ISS's president, indicated that he was disappointed with the approach the representative had taken, but it indicates the leverage. In addition to operational conflicts, there are also ownership conflicts. We've talked in this committee before about this in the subcommittee. Glass Lewis is owned by the $170 billion Ontario Teachers Pension Plan Board, which engages in public and private equity investments, in which Glass Lewis makes recommendations. And in addition to that, there are issues around errors and inaccuracies. A 2014 Center survey I cited earlier indicated that a final report had one or more errors. Mr. Chairman, as I conclude, we believe that a more formal and appropriate regulatory regime, such as that included in the Proxy Advisory Firm Reform Act, would help address the conflicts of interest. And we've seen before that where there's been specific oversight of the regime and of the issues, it's had an impact on the conduct of proxy advisory firms. And I'd be happy to talk more about that during the question and answer period, but we believe that the structure is definitely worth considering and a worthwhile initiative. Thank you for the opportunity to testify, and I look forward to your questions.
And thank you. Next, up from the Vermont Law School, Professor Taub. Welcome. Recognized for 5 minutes. Is that pushed? The button pushed all the way? Or maybe lean forward, too, if that helps.
Chairman Garrett, Ranking Member Maloney, and distinguished members of this subcommittee, thank you for this opportunity to testify today. My name is Jennifer Taub. I'm a professor at Vermont Law School, where I teach business law classes, including corporations and securities regulation. Before joining academia, I was an associate general counsel at Fidelity Investments. I offer my testimony today solely as an academic and not on behalf of any other association. In this brief opening statement, I will highlight the concerns that I have with each bill. For a more comprehensive exposition, I would refer you to my written testimony. First, the Investment Advisors Modernization Act allows private funds to retreat into the shadows once again. The word private is somewhat misleading these days. Consider that 1/4 of the equity in private equity funds comes from public pension retirement funds. And please recall that private funds, including hedge funds, can now be marketed through general solicitations to the public. It's odd. Just when private equity funds are in the sunlight, thanks to Dodd-Frank, and many have been exposed in SEC examinations as in violation of the law, including for misallocating expenses, you are now proposing that they be able to hide their tracks. Instead of encouraging a culture of compliance, this bill would provide a loophole for investment advisor record-keeping requirements, subjecting communications to confidentiality agreements or keeping them in-house would allow advisors to destroy critical investment records. This bill would also exempt all private equity fund advisors and many hedge fund advisors from submitting a completed Form PF. This information that would be withheld is important to monitor for systemic risk and to protect investors. This bill would block the SEC from broadly banning materially misleading statements in private fund sales literature, including concerning fund performance. This is backwards. The SEC should be encouraged to, not discouraged from, making rules against fraud. With Rule 506C pursuant to the Jobs Act, private funds can now be advertised through general solicitations to the public. Public offerings were supposed to come with commensurate broad protections against fraud. This bill would also weaken the SEC's ability to stop false advertising by advisors generally, including to certain retail investors. And it would shockingly eliminate the annual independent audits of certain fund advisors to ensure they actually have the assets and securities they claim to hold. This should be called the Madoff loophole. Next, the SEC Regulatory Accountability Act would limit the agency's ability to protect the investing public. Prior to issuing most regulations, the SEC would have to engage in a new cost-benefit process. Yet the SEC already conducts economic analysis, and the securities laws already require the consideration of the promotion of efficiency, competition, and capital formation. The SEC is already subject to the Paperwork Reduction Act, the Regulatory Flexibility Act, the Congressional Review Act, and the APA. The existing requirements set out several speed bumps. These proposed requirements are tire shredders designed to bring progress to a crashing halt. Notably, this bill would require the SEC to consider endless alternative approaches and only select the one that maximizes net benefits. How could this be measured with any precision? It can't. As Harvard professor John Coates notes, it's not possible to specify and quantify all benefits and all costs in a single uniform bottom-line metric representing the net welfare effects of a proposed rule. The results are not precise, but instead what he calls guesstimations. What this bill mostly creates is opportunities for litigation and legal fees to be generated. Finally, the Proxy Advisory Reform Act represents paternalistic overreaching that is unnecessary and could entrench existing firms. These firms are business success stories. They help institutional investors cast votes on important corporate governance matters at the portfolio companies they own. The SEC already has the authority to examine and discipline any institutional investors who mindlessly follow advice without considering their fiduciary duty to underlying investors. And the SEC has authority under the Exchange Act and the Advisors Act to address conflicts of interest. Thank you for this opportunity to speak. I look forward to your questions.
I thank you. From the Center for Competitiveness, Mr. Gwadman, welcome back to the panel, and recognized for 5 minutes.
Thank you very much, Mr. Chairman, Ranking Member Maloney, members of the subcommittee. Thank you for the opportunity to testify today. The SEC's domain are the public capital markets, and its mission is to promote investor protection, competition, and capital formation. By many metrics, the SEC is missing the mark. For the last 19 out of the last 20 years, we've seen a constant decline in the number of public companies in the United States, to the point that we have less than half of the public companies today than we did in 1996. The bills that are before us today are for smart regulation to have appropriate oversight for the benefit of investors and the businesses that they invest in. The SEC Regulatory Accountability Act is based upon the executive orders issued by President Reagan, President Clinton, and President Obama. It enshrines those executive orders into their rulemaking process. This bill also has some very innovative means to make rulemaking even more successful. As an example, the post-implementation economic analysis allows for the use of precise economic data 2 years after the rule writing to look at exactly what the costs are, what the benefits are, if the rule is working, and if not, what changes need to be made to the rule. Additionally, the mandatory look-back of major rules allows the SEC to separate the wheat from the chaff. That is, for those rules that are obsolete, to take them off the books. Those rules that need to be tweaked should be tweaked. and for those for those issues that are looming, to have the SEC actually write rules before they become a problem. So in short, this bill is designed to impose rigor and discipline in the rule-writing process to the benefit of both investors and businesses. The Proxy Advisory Firm Reform Act of 2016 that has been introduced by both Congressman Duffy and Carney are important steps forward. Proxy advisory firms are necessary because we have institutional investors who can invest in thousands of companies. As has been noted, we have two firms that cover 97% of the market share, and that they have become de facto corporate governance regulators. However, proxy advisory firms are also beset by many problems. One firm has 180 analysts looking at tens of thousands of companies globally and making recommendations in 250,000 shareholder proposal and director elections. Proxy advisory firms have been beset by conflicts of interest, lack of process and transparency in how they develop their vote recommendations and voting policies. There are questions about their error rates as well as a lack of input. Some institutional investors use proxy advisory reports as data points in their independent judgment of how they execute their votes and shareholder proposals. Other investors, however, outsource their corporate governance voting responsibilities in toto. For those investors, that becomes a difficulty in determining how they can meet their fiduciary obligation to the people who invest in those funds. The 2014 SEC guidance, which was only issued as a result of the 2013 hearing of this subcommittee, is a step in the right direction, but this bill provides for more oversight. This bill would have proxy advisory firms create transparent processes for the development of voting recommendations and policies. It would allow for further disclosure and management of conflicts of interest, and it would have the proxy advisory firms demonstrate to the SEC that they have the resources needed to meet their due diligence. Furthermore, to give one example, proxy advisory firms make recommendations on shareholder proposals when a proponent is a client. That is no different than the problems 10, 12 years ago with the conflicts of interest with financial analysts. Finally, the Investment Advisor Modernization Act by Congressman Hurt is an important step forward. Dodd-Frank Act requires the SEC to build transparency around private equity firms. However, there's been a regulatory mismatch. The SEC is imposing public company tools on private equity partnerships. That's like using a meat cleaver when we should be using a scalpel. The bill would allow the SEC to tailor regulations. So in conclusion, Mr. Chairman, we would have liked to have seen the SEC move forward on these issues on their own. However, we believe that at a minimum, congressional pressure is needed to make the SEC move forward. But if the SEC is not willing to move forward, we look forward to working with you, the co-sponsors and members of this subcommittee, to have these bills become law. Thank you.
Thank you. And last but not least ever, from Blue Wolf Capital Partners, Mr. Chericito.
Yes, thank you.
Welcome. You're recognized for 5 minutes.
Chairman Garrett, Ranking Member Maloney, and members of the subcommittee, thank you for this opportunity to testify today on important legislation that, if passed, provides a modernized regulatory framework that is efficient and meaningful, allowing private equity advisors to continue to focus on growing companies, providing important returns to our investors, most importantly, working families counting on a secure pension when they retire, while helping to create jobs now and in the future. On a personal note, good jobs is something that I care deeply about. As I began my career as a union organizer with SEIU, and the ability of private equity firms to be strategic partners and investors in creating and sustaining good jobs is what brought me to work in this industry. My name is Joshua Chericito, and I'm the Chief Financial Officer of Blue Wolf Capital Partners. Blue Wolf provides investment and strategic support to good, small to mid-sized companies often not served well by public markets because of challenges they face. We take seriously our fiduciary responsibility to our investors as stewards of their capital and managers of our portfolio companies. We invest responsibly and believe strongly in a culture of compliance and transparency. I'm also honored to be testifying on behalf of the Association for Corporate Growth, a global trade association created to drive middle market growth on Main Street, focused on companies with revenues between $10 million and $1 billion. The association directly serves 90,000 M&A professionals within the middle market, including more than 1,000 private equity firms like ours, which invest in local communities and help create jobs throughout Main Street America. Let me briefly share an example. Healthcare Laundry System is a leading provider of hospital-grade laundry service to the Chicago area, spanning more than 550 healthcare providers, including more than 40 hospitals, and employing more than 500 people. Despite the firm's compelling market position, it had challenges precluding it from raising capital from the public markets. Blue Wolf, by working in partnership with management, government, the employees, and the multiple unions representing them, we were able to provide capital and strategic support to create a stronger business with more quality and stable jobs. Having addressed these challenges, Healthcare Laundry System was later sold to a public company, providing long-term stability to the company and its employees. I'm here today to support the Modernization Act that would modernize the 40 Act so that the law better reflects the vast market and technological and structural changes that have taken place over the past 76 years. Due to the 40 Act's ambiguity in today's world, firms like ours spend many hours and significant dollars trying to comply with ill-fitting rules for our industry that don't further the intent to protect investors, including on advisors and lawyers trying to interpret regulations not specifically written with our industry in mind. An example of the bill's common sense approach is the advertising rule, an outdated provision from 1961 designed for public retail marketing. Private equity advisors advertise exclusively to qualified, sophisticated investors and already have a robust private placement disclosure process which should continue to be regulated and reviewed. However, the 40 Act did not contemplate and could not foresee how to regulate technology advances such as websites. Unlike the retail market, private equity websites are not aimed at investors, but instead are used to more efficiently connect with companies and management teams looking for an investment partner. It is important to note that basic anti-fraud provisions of the federal securities laws would remain in effect for all private fund advisors. Just imagine if you were asked to operate under the House rules of 1940, restricting communications to your constituents to the regular mail. We recognize and value transparency, accountability to regulators, operating in the open, but most importantly today, we seek to update the regulatory framework to increase our focus on growing companies on Main Street across the country. For Blue Wolf, that means from Madawaska, Maine, to Suwanee, Florida, to Chicago, Illinois, to Santa Barbara, California, creating good, sustainable American jobs. Thank you for this time this afternoon, and I look forward to answering your questions.
I thank you. The gentleman yields back. And thank all the members of the panel. At this point, we will turn to questions, and I'll recognize myself for 5 minutes. I guess I'll start with Dan, or Mr. Gallagher. So you heard my opening comment talking about our legislation dealing with the cost-benefit analysis and what could be the benefit of having such an analysis. What does it do? It gives the opportunity or the requirement to an agency, which is what the President basically has already asked agencies across the spectrum to do, and what the SEC has already said they would do, and all we're doing is now trying to do what? Codify that and say, going forward, you always have to do it. To look at every angle, if you will, every permutation, see what can be the benefits and the consequences of a rule. Now, that's all well and good, but there's another angle to this I want to get into, and if you can, joint rulemaking. So we've seen some joint rulemaking for various agencies in the past, most notably is in the area of the Volcker Rule, and when that's done, you have various agencies doing it. When that was done, SEC looked at analysis, other agencies look at it, some don't. Talk about if this legislation were to pass, or if it had been passed, what would be the effect on joint rulemaking? Could the agency get out of it, or what happens?
Well, thank you for the question, Mr. Chairman. In practical effect, the legislation, as you point out, because it would make years of guidance and disparate regulatory and legislative requirements binding in the U.S. Code, I think it would cause the SEC in the context, let's use the Volcker Rule since you mentioned it, to actually not be able to lawyer the situation in a way that I cautioned in my opening comments. And so, as you might recall, in the Volcker Rule, the Volcker Rule was promulgated even by the Securities and Exchange Commission under the Bank Holding Company Act, not the Securities and Exchange Act of 1934.
Yeah.
So the various disparate legislative requirements, in the Exchange Act, the APA, everything else, didn't apply because the lawyers determined that pursuant to the Dodd-Frank mandate on the Volcker Rule, that it was legal and permissible for the agency to promulgate the rule of the Bank Holding Company Act.
Yeah, so I guess I want to be clear, and I'll go through Mr. Quadman if you want to jump in here. If we have this law now, and you go into a joint rulemaking territory, and the SEC has to do it, I'll throw it to Mr. Quadman. Would you say that the SEC has the ability, they would do the joint rulemaking, but would they have the ability, they would do the analysis, would they have the ability basically to stop the joint rule from going forward then?
No, so in fact, we have a situation right now with the incentive comp rules, which are being released, where you have 5 agencies have not done any sort of economic analysis, and the SEC has. I think also to Commissioner Gallagher's point with the Volcker Rule, no agency did an economic analysis with the Volcker Rule. So what we have now is we have markets where we have liquidity stresses, which should have been picked up in an economic analysis of that rulemaking.
Did you have last point on that? Or no?
Yeah, I think, so basically, this standalone statutory requirement would not allow the Commission to seek rulemaking authority other than the federal securities laws. And so where the Bank Holding Company Act did not require cost-benefit analysis and economic analysis, this standalone would force them to do it, even in the context of Volcker. And I'll just, one little small point, too.
Yeah, sure.
Just so this committee knows to keep an eye on this, the Commission still needs to promulgate a rule to make the Volcker Rule enforceable under the federal securities laws, under the Exchange Act. Now, that would change the baseline of the economic analysis when they conduct that rulemaking because the Volcker Rule exists today. If they had done that back in 2013, it would not have existed, so the baseline for the economic analysis would have been much different than what you're going to get whenever this rulemaking happens.
Right, and I only have a minute left to hit 10 more questions, so. One question is, so oftentimes the charge is that what we're trying to do is undo regulations or undo rules or peel things back. If you do a cost-benefit analysis, is that really the case, or really what you're doing, I'll throw it to Mr. Quadman again, is that really what you're doing, or you're trying to get the most efficient, cost-effective approach and helping both the industry and investors or what have you, but also the agency itself to most perform effectively?
Yeah, no, and I think what your bill does, it does it in 2 ways, right? One is not only during the rulemaking process that you actually get a sense of what the potential costs and benefits are, and then figuring out the right way to get at the objective of the rule, but then when you take a look at it 2 years post-implementation, you're actually looking at real numbers that will allow you to get to the point of if the rule is working or how you need to change it.
Okay, I have a whole bunch of questions on proxy advisors, and I'm not going to go over my time. Maybe I'll circle back. Due deference to the other members here, I will yield now to 5 minutes to the gentlelady from New York.
Okay, thank you, Professor Taub. I'd like to ask you about the private equity bill. You noted in your testimony the bill amends the books and records rule, which requires investment advisors to keep key records of transactions they execute for their clients as well as investment decisions. The bill would provide a broad exemption to the books and records rule, and I'm concerned about how that could affect the SEC's ability to examine investment advisors and ensure that they're complying with the law. Can you discuss a little bit more why the books and records rule is important and whether the bill's exemptions to the rule are too broad?
Thank you. That's a really great question. So the record-keeping requirements are basic business records, as you've noted, and it includes things like investment, advice given, and it includes the way that it would interfere with the SEC's ability to do examinations is that it is these communications between employees. They could be communicating by email, or they could be communicating in writing concerning transactions that could now be destroyed, for example, or even external communications, as long as they were subject to confidentiality agreement, there would be no record of those. And in the first examinations of, for example, private equity funds that began in 2012 resulted by mid-2014. There were about 150 of the firms examined, and over half of them there were either legal problems or problems with controls. And the SEC found mostly problems with expense allocation and also problems with fee disclosure. And all of that, to be able to discover whether there's been one story told to the investor and a different story communicated in-house, you actually need those records, and this would permit those records to be destroyed.
Okay, you also stated in your testimony that the private equity bill's exemption to the custody rule should be called the, quote, Madoff loophole, end quote. Could you elaborate more? How would this exemption have helped Bernie Madoff?
The reason why I called that the Madoff loophole is because I was recently rereading Dan Enriquez's wonderful book called Wizard of Lies about Bernie Madoff. And one of the things that folks fail to check is actually see if the assets and securities he claimed to have were truly there. And in this bill, there are exemptions from what is now required by the ACC, which is an annual surprise audit. So you have an independent audit firm that doesn't tell you they're coming in, and they're supposed to come in and see if you actually have your client's money and securities. It seems like a very sensible thing. And the carve-out in this legislation, the reason why I'm calling it the Bernie Madoff, the carve-out is for family, it's if you only run money, manage money and assets for family members, and there's a whole long list, and one is for investors you have a relationship with. And if you think about Bernie Madoff and other folks, there's this affinity fraud. The definition of who you have a relationship with, these are all built on relationships. It's far too broad. And moreover, I don't see why anyone would object to why any honest investment advisor would not want to assure their investors that their money is actually there. So it's an invitation. It's basically tying the SEC's hands, and it's an invitation for fraud to flourish in the shadows.
Thank you. Mr. Quadman, I'd like to ask you about proxy advisors, and I understand that there's still disagreement in the academic literature about the influence of these advisors. Some studies find them very influential, while more recent studies find that their influence is limited and even declining. Some of the biggest asset managers tell me that they use proxy advisors primarily for their centralized data management on all of the shareholder meetings and to help them actually cast the thousands of votes that they have to cast every year, and not as much for their vote recommendations. So I'd like to ask you first, how do you respond to the studies that show that proxy advisors aren't very influential anymore? And secondly, if proxy advisors' vote recommendations are less influential than they were a decade ago, is there still a need for aggressive oversight of these firms?
Yeah, let me answer that in a couple of different ways, Congresswoman. Number one, you have the Edmer study out of the University of Colorado, which shows that ISS and Glass Lewis control about 36-37% of the vote. You have the Larker study, which shows that they don't, that the ISS recommendations are not necessarily geared towards better economic return. And just lastly, I spoke to a CEO last year who received a negative recommendation on a comp plan, and 33% of the shares were voted within 24 hours of ISS and the Glass Lewis recommendations, and 90% of those shares were voted against the company. I think that in and of itself shows they're still pretty influential.
Thank you. The gentleman yields back. Vice Chairman of the committee, Mr. Hurt, recognized for 5 minutes.
Thank you, Mr. Chairman. I had a question for Mr. Cherry Cito and hopefully be able to get to Mr. Quadman and Mr. Gallagher. But I wanted to begin with you, Mr. Cherry Cito. You're the CFO of Blue Wolf Capital Partners, is that right? And obviously your firm has to engage in a lot of compliance with regulatory agencies, is that correct?
That's right.
You take, is that expensive?
It definitely takes a lot of time and attention.
And it's time consuming?
Yes,
Do you take it seriously?
at all levels of the organization.
Do you think the SEC's responsibility for investor protection is important?
Absolutely,
And do you all take that seriously?
absolutely.
I guess my question really deals with a couple of things that Professor Taub said. You touched in your testimony about the advertising rule and the necessary change that this bill would bring to that rule. But I was wondering if you could talk a little bit about the custody rule and the record keeping and the Form PF. And A, do these changes, these proposed changes in any way jeopardize investor protection? And B, if they do not, how do they help your company or your firm and the employees that they hire?
Let me try to take a stab at the books and records piece of this legislation. Part of the issue here is that engagement with the industry is important so that we can figure out how to come up with regulations that are common sense with the way that the industry operates. In the case of books and records, I think the intent of that section is really talking about keeping records of investment advice. When the laws were made, it was very clear what you meant by investment advice. If you engage a broker and that broker comes to you and says, I think you should buy this stock, they've made an investment recommendation to you, and then the SEC could say, well, let me look behind and see what the research was for them making that recommendation. In the private fund space, you've engaged a private fund manager like Blue Wolf to work on your behalf to make investments. In this case, we're not coming back to the investors every time we're looking to invest in a company. We're doing that in our own governance structures, where there may be an advisory committee of LPs that help look over. But on a day-by-day basis, we're making recommendations to our investment committee, which is within the firm, on investments that should be made. I think what this legislation is trying to address is that in the course of doing work, we look at all sorts of investments, many of which don't get consummated. Those investments that don't get consummated are most of the record keeping that we're talking about. And where's the investment advice in a prospective investment that never happened?
And what does that have to do with investor protection?
Well, if the investment's not made, I don't think it's really doing much to protect investors. If an investment is made in a portfolio company, we do have an obligation to keep the investment committee minutes, the information around the investment committee memos that are put together to support an investment. But there are many, many more investments that never make it that far.
Okay. Mr. Gallagher, from your time at the SEC, I would imagine that you've I know that you've struggled with a lot of the things that these firms have to go through now that they have to register. I guess my question is Ms. Taubman couches this as a either-or thing, that investment protection is at odds necessarily with capital formation. And I guess my question is does it have to be that way? Aren't there ways to promote capital formation and at the very same time maintain investor protection?
Oh, absolutely, Congressman. In fact, one might look at it and say, as I used to when I was on the commission, promoting capital formation is increasing investor opportunity and the ability to choose service providers, the ability to choose products that otherwise wouldn't exist, which is good for the overall economy, but really good for investors and creates a more competitive market in which the malfeasors might not succeed because there's real competition. So there is a natural regulatory inclination to reduce opportunity, to protect a very nanny state-like instinct in the regulatory agencies these days to reduce opportunity, and I think that's the actual detriment and a loss of protection for investors.
Thank you. I yield back.
Gentleman yields back. Mr. Scott, recognized for 5 minutes.
Thank you, Mr. Chairman. Very good hearing. It seems to me that these bills are sort of put forward to maybe spur a greater concern with the SEC to move faster in doing its job. However, I have a couple of pertinent questions that go to this point. Back in 2010, for example, there was a staff report from the Federal Reserve Board of New York that argued, and I quote, "Along the chain of intermediaries in the shadow banking system, the weakest link in that chain is the pinch point that can destabilize the entire chain." Now, when that staff report was released in 2010, we were on this committee finishing up passing Dodd-Frank, and one of Dodd-Frank's main objectives was to fill the regulatory gap that was created by this shadow banking system, thereby making our chain stronger. And to that end, and I was a co-sponsor of the Dodd-Frank bill, we were working on the bill, and at that point, we made sure that Dodd-Frank brought private fund advisors with more than $150 million in assets under management out from the shadows and into the bright light of the oversight of the Securities and Exchange Commission. So my question is, given all that we've done, what evidence do we have today to suggest that now is the right time to loosen the SEC's grip? Any one of you?
I'd be happy to respond to that. And I have read that report, but first I do want to respond to something that Mr. Hertz said, suggesting that in my testimony I stated that investor protection was at odds with capital formation. In fact, I've always stated the opposite, and my written testimony indicates that they actually are perfectly aligned, and that it is trust in our financial markets that encourages people to invest and actually can decrease the cost of capital because there can be a premium on capital if you think someone's going to cheat you. But back to the question about shadow banking and Dodd-Frank and how this bill could affect that. In particular, the provision in the bill that would allow private equity firms and some hedge funds to no longer complete Form PF. I think it's very important. The Form PF, as you know, is provided to the SEC confidentially, and access is given to the Financial Stability Oversight Council. And these data have only been collected since 2011, and getting a picture of the behaviors in broader market is really important. And the part of the form we're talking about is Section 4 for the private equity firms, and it provides important information related to leverage and counterparty risk, and also geographic and industry breakdown. And the importance of knowing about, obviously, leverage was a key factor in the financial crisis, but counterparty risk is important because of the links that you're talking about. The second thing, though, that goes really to the heart of shadow banking is Section 1C. This is a part that's only filled out by hedge funds. If this bill were to pass, hedge fund advisors with between 150 million and 1.5 billion assets under management wouldn't.
I have only,
Yep.
I'm sorry to interrupt you, but I
It's okay.
have appreciate that response. But I did have one other question I wanted to get in concerning Mr. Garrett's bill, because I have a belief and have supported cost-benefit analysis. But I do want to raise the issue because back in, I think, around 2013, SEC Chair Mary Jo White said that she was conducting economic analysis. And I'd just like to clarify your statement, Mr. Gallagher, because it goes to the point that the chairwoman of the SEC made, that perhaps Mr. Garrett's legislation would hamper the SEC's ability to do rulemaking in a timely manner. I wanted to get you on the record to please explain that, at least give some response to the chairlady's concerns of the SEC.
Sure. Thank you for the question, Congressman Scott. I am an end user of economic analysis. I've gone through many rulemakings, mostly Dodd-Frank related, over the last several years. Economic analysis has never once slowed down the process. In fact, my experience is that it speeds up the process because it provides decision points and optionality for policymakers like myself who need to vote on these rules where you otherwise wouldn't have it, where it would be one size fits all. It lends itself to negotiation. There were several Title VII rules on derivatives my first year in 2012 that, but for the economic analysis, we would have had split votes of the commission. Instead, we got 5-0 votes, and we got them in a timely manner. So I think this bill is actually, to Chairman Garrett's original point, only incremental in its burden on the agency over what the agency is committed to in 2012. What it does is it clarifies and codifies, which is incredibly important, in a standalone way, these obligations that the agency has mostly already committed to. So I think it's a very positive step.
You do understand, Chairwoman White's concerns are legitimate. I just want a yes or no on that.
When you run the agency, you're always worried about pressure to get things done, running the agency. The chairman has so many other duties than the other commissioners, so any other imposition, any other mandate coming from Congress right now, if you're trying to run the SEC, I can see would be a burden in her eyes, but I don't think this is a real material one at all.
Thank you, Chairman.
Thank you both. Gentleman from Texas is now recognized.
Thank you, Mr. Chairman. Mr. Cherry Soto, do you believe that private equity funds represent a systemic risk?
Do I personally feel that they...
Yeah.
I wouldn't say that I was an expert on the matter, but there have been a number of folks that I think are better investors than me that have said that that's not the case.
Do you think that private equity firms caused the financial crisis we had in 2008?
I don't think I'm an expert to speak on that, but I would say that a lot of private equity firms, especially small ones, look much smaller than any holding company. You have a holding company that happens to not be run by a private equity firm, is either privately held or public, that are much larger than our firm. I mean, our firm is fairly typical for the middle market. There are thousands of firms of our size, manage under $500 million of capital. We have majority interest in 10 or 12 companies.
So I think one of the things I wanted you to do is maybe explain who's a typical client of a private equity company.
Here often pension funds are big investors in private equity assets.
So they're sophisticated investors, is that right?
They're definitely investors that have access to legal support. Most of them have advisors that this is the only business they advise on, not only for investments, but specifically on alternatives in the private equity market. Very sophisticated advisors.
Mr. Gallagher, would you concur that, what is your position? Do you think that private equity companies are a systemic risk?
Absolutely not.
And you don't think they had anything to do with causing the crisis?
Absolutely not. I think they got swept up into Title IV. Lord knows why I wasn't here for that process, and I don't think the regime fits the business model.
The President signed an Executive Order 13579, which requires an independent regulatory agencies to perform an analysis of rules that are, quote, ineffective, insufficient, excessively burdensome, and to modify, streamline, or repeal them in accordance to what they have learned. While you were a commissioner at the SEC, were you aware whether the SEC took part in any kind of analysis like that to comply with Executive Order 13579?
No, unfortunately, Congressman, it never happened. There was a lot of talk about it, but it never happened.
Why do you think that was?
Well, it was a very regulatory time during my tenure on the commission. The emphasis was on promulgating rules, not reviewing them, not writing them off the rule books.
In your testimony, I think you said the SEC was constantly bombarded with pressure from special interest priorities. Could you describe some of the examples of what you see as the SEC's missteps in terms of setting its own priorities?
Look, it's since 2010, since Dodd-Frank, when the SEC was mandated by Congress to conduct roughly 100 rulemakings, studies and the like, the agenda has effectively gotten away from the agency. As you well know, a lot of these mandates had 2-year timeframes. Here we are, it'll be 6 years, I believe, here in July, since the enactment of Dodd-Frank, and the agency still has roughly 35–40% of the final rulemakings to do. So the rulemaking agenda has been dominated by Dodd-Frank, and I think within the Dodd-Frank mandates is where I often squabbled with my colleagues on the commission, prioritizing those mandates, I thought, was askew, the best evidence of which is that my first 10 months on the commission, a quarter of my time was spent on sections 1502 and 4 of Dodd-Frank, conflict mineral disclosure and extractive resource disclosure, when here we sit today and the Title VII derivatives rulemakings remain unfinished.
But you talk about the external, I guess, special interest priorities. Do you think that was influencing more of the agenda, or trying to knock out some of the Dodd-Frank?
Yeah, Congressman, I think the squeaky wheels got a lot of the grease. So, you know, the 1502 rulemaking here, again, is instructive. There was, why did I spend 25% of my first 10 months on it? Because it was a steady parade of special interest groups on all sides of the aisle, pro, for, you know, and against the rule, coming in to meet with us and push this to the front of the agenda. That 1502, you know, I accept the wisdom of Congress. This was something that had to be done. It's the law of the land. Someone needed to realize that it was not going to happen, you know, that these 100 mandates were not going to be completed within 2-3 years, and 1502 should have been at the end of the pile, not the beginning.
Thank you, gentlemen. I yield back.
Gentleman from Connecticut is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd love to just direct a few questions to Professor Taub. And by way of background, I worked with Mr. Hurd on a bill a number of years ago that would have provided exemptions from registration to larger and more leveraged private funds. And at the time, the theory was that they are not systemically dangerous, which I happen to continue to believe, and that limited partners in these funds, as sophisticated investors, don't require quite the same oversight and assistance that retail investors do. I look back on that with some ambivalence because I still think that those two things are true, but obviously the SEC used the filing of Form FP to identify a not inconsequential amount of skullduggery with respect to fees, conflicts of interest, and many of their exams resulted in some disclosures that were really pretty uncomfortable for the way limited partners in these funds were treated. So I approach this question with these questions with ambivalence. I continue to believe, Professor Taub, that a private fund is not the same as a mutual fund. They tend to hold private securities as opposed to public securities. They tend to deal with sophisticated investors. So I'm wondering if we can drill in. And as you look at the elements of the proposed HURT legislation here, I'm really interested in your opinion, because I think your critique was pretty good. But is everything in here a bad idea? I mean, let me just rattle off a couple to get your hopefully quick opinion on. You know, the delivery of brochure to clients, that exemption would apply only if a prospectus had been delivered. So I'm wondering, should I be concerned about that? The exemption from annual independent audits and surprise examinations is only in the case of limited partners that are insiders, family members, family offices. You're shaking your head. I'll give you a chance because I'm asking this honestly. I'm not making a rhetorical point here. You know, on the client notification on consent to ownership changes, that strikes me as sort of administrative in nature. So I do, Professor Taub, want to give you the opportunity. Is everything in this bill a bad idea, or is it possible that some of these things, including what I've just listed, is in fact a tailoring of legislation to the fact that private funds are not in fact mutual funds?
Thanks so much, Congressman. I appreciate those questions. I want to answer it, but you also made a comment which I thought was interesting about sophisticated investors. And I did write a paper entitled "The Sophisticated Investor in the Global Financial Crisis." And what's interesting is, sorry to bring up Bernard Madoff again, but if you think about a lot of his money came through feeder funds. The feeder funds were giant sophisticated investors. Themselves, you know, these were fund-to-fund structures. So if a sophisticated investor is being lied to and provided false information, I'm not exactly sure how that benefits capital formation. But to your specific...
I don't want to cut you off. Look, I don't think we can build an entirely regulatory structure around a Madoff possibility. Obviously, Madoff undertook a lot of very illegal activity, but I really am interested in whether your opinion is, in particular those three areas that I highlighted, Is this a collection of totally bad ideas, or am I right that some of these things actually may be fairly reasonable tweaks to the regulation?
So quickly, since you mentioned the brochure is basically part 2 of this Form ADV that has to be filed. And the reason why it's still important, even if prospectus has been given, is that it's written in plain language. It has to be updated. And in this brochure, the advisor has to disclose if there's ever been any disciplinary actions. Listen, there are so many good...
Does that not need to be disclosed in a prospectus, though?
It has to, no, because if the disciplinary action happened after not the prospectus, but the offering document, then it would not have appeared. So if they get in trouble, I think, like I said, there's so many good advisors. Why shouldn't there be a fair playing field, and those that do have disciplinary actions disclose that? The thing with custody is it's not just for firms that only have the limited partners as family members. It's anyone who has a relationship. And, the term relationship is not defined. So that's of concern. If you wanted to go line by line, I'd be happy to define, something in here that I didn't find troubling. I only highlighted the things that struck me as problematic. Thanks.
Okay, thank you. One last question in my limited time. It does seem that the Form PF did, and I'll look at the whole panel on this, give the SEC some information that it used to find some troublesome behavior with respect to fees, in particular, and conflicts of interest. Professor Laub cites in her testimony the work of a Professor Call, who indicates a $10,000 cost associated with Form PF. Does the panel disagree that Form PF in and of itself is not outrageously burdensome?
I don't think that these fee issues were discovered through PF, if that's my recollection. It was a regular way examination by SEC examiners of the books and records of the advisor. PF is wholly separate information to be provided for systemic.
So we're back to the independent audits and surprise audits? Is that what?
The gentleman's time has...
It's regular audits. PF doesn't make any sense for private equity.
Okay.
Has
Okay, thank you. Thank you, Mr. Chairman.
Yep. Ms. Wagner?
Thank you, Mr. Chairman, and thank you all for joining us today for this important hearing and discussion on reforms we can introduce at the SEC in order to make sure that capital is allocated as efficiently as possible and that shareholder value is prioritized. Increasingly, we have seen government get in the way of our capital markets and the ability of public companies to grow and expand their business on behalf of their employees and shareholders. For small companies that are continuing to expand and grow, this often results in them staying private longer than deal with extraneous issues of being a public company, especially when the cost of going public is estimated to be $2.5 million at first, with continuing annual costs of $1.5 million. Mr. Quadman, welcome back. Good to see you. In your testimony, you note that, and I quote, "For 19 of the last 20 years, we have seen a number of public companies decline. We now have fewer than half of the public companies than we did in 1996. Could you please explain why you think that this has occurred?"
Well, I think you put your finger on one of it in terms of the IPOs and the difficulty there. The other, quite frankly, is, let's call it the Michael Dell problem, where you have an entity that's a public company that is faced with a lot of these costs and burdens and the annual fights that they have to go through in terms of shareholder proposal and director elections. And that takes up so much time and effort that management actually begins to move away from managing the corporation for the long term. So there you actually had a company that decided to go from public to private, and Michael Dell said he would never operate a public company again because he would rather manage a company than having to deal with these fights. So I think if we had, as an example with the proxy advisory firms, if we had more oversight there and we had openness and transparency that we expect in other areas, that might help alleviate things. But we do not have a hospitable environment either to create or remain a public company in the United States.
Well, moving off of that and expanding a little bit, for small companies that are looking to go public, they have to see all of these pressures that you've talked about a little bit here briefly, that they'll encounter from activists and battles on proxy votes that promote priorities, and this is my biggest concern, they promote priorities that have nothing to do with long-term shareholder value. How much of a disincentive does this make for those small businesses that are looking at going public? And how can we improve outside of what you mentioned vis-a-vis oversight, this corporate governance climate, so to speak?
Yeah, I think we can spend a whole day answering that one question. Number one, I think just creating the small business advocate, which this subcommittee has been in the lead on, is really important to get a voice for capital formation and competition in the SEC, one. Two, I think it's really important not only that we get more oversight, but that we have more of an emphasis on what do we need to do in terms of capital formation. So, if we take a look at it, that we have a very diverse capital system, we need to have private equity, but we also need to have public companies. So in order to deal with, let's say, proxy advisory issues, that's a very important thing to deal with, because companies just will not decide to go public because of issues like that. In fact, if you go to Silicon Valley, the two reasons why they will tell you they will not go public, one are proxy advisory firms.
Right.
Two is the internal control costs placed on them by the PCAOB.
Okay, let me move on, Mr. Quabbin. Thank you very, very much. Mr. Gallagher, good to see you again. I'm increasingly concerned that shareholders' interests are not truly being represented by this proxy system. How has the current complexity of the proxy system contributed to inaccuracies in the processing and recording of proxy votes?
Congressman, I've heard over the years, anecdotally, so many stories of failings on the part of the proxy advisory firms, whether they be bad recommendations or mechanical issues and the like. And that's one of the reasons I got so inspired to pay attention to the issue. As a commissioner, you often act as an ombudsman for complaints and the like.
And in my limited time,
Yes.
Mr. Gallagher, is there any way we can simplify the system to make it more beneficial for the owners and I should say on behalf of the owners, for the intermediaries? When was the last time that we did something like this?
I think it's about time that Congress take a look at what I had called as a commissioner the federalization of corporate
Right.
governance, find the touch points where the federal government has been inserted to which otherwise is a state law system dominated by Delaware in particular, and decide, does it make sense? 14A8 shareholder proposal rule is out of control. It needs to be revisited. If not the SEC, then it should be this Congress.
It's past time that we update this
It's past time, and there are these touch points. And I
Thank
do
you
think
very much.
that
I'm out of time. I yield back, Mr. Chairman.
The gentlelady yields back. The gentleman from California is recognized.
Okay. A couple comments on proxy advice. I think it's an attack on capitalism to tell investors that it is virtually illegal for them to consider anything other than earnings per share in making their investments, that they're silly or that they're not to be given the information they want. And if investors want to prevent companies from investing in Iran, if they want to be interested in the political contributions that are made with their money, if they want to avoid their companies or at least know how their companies are engaged in blood diamonds and conflict minerals, that investors have a right to that information, and they have a right to even vote on whether the company should engage in those activities or not. And to say that investors must only consider earnings per share is to say that the investor doesn't own their own money, cannot make decisions that reflect their own values. So I would say I believe in openness and transparency with proxy advisory firms, but not if the purpose is to prevent openness and transparency by the operating companies in which solicit those proxies. And likewise, openness and transparency includes a real audit that we can rely upon that includes many times internal controls. Commissioner or former Commissioner Gallagher, I want to direct your attention to the bill to deal with the NMS. We have that playing an important role in SEC regulation of the exchanges. The exchanges, on the one hand, are a regulator. On the other hand, they're a market participant. They're for-profit companies who derive most of their money to making sure that some investors know about what's going on a microsecond before other investors know what's going on. So they're profit-driven, and they are in favor of transparency, but some transparency, some are entitled to transparency a millisecond before others. The NMNS includes the exchanges, but doesn't include other industry participants, such as the consumers of the exchange service, namely the brokers, and also the asset managers, those on the buy side. Does it make sense from the NMS plan to include folks other than the exchanges themselves?
Thank you for the question, Congressman. As a commissioner, I heard lots of complaints on both sides of this debate. I had the brokers come in particular, complaining that they didn't have a real voice or ability to impact the direction of NMS plan participants. I heard from the exchanges making the exact counterpoint without sitting in these rooms during the plan debates. It was hard for me to actually decide where the truth lied. And I know that this committee and others in Congress are interested in this issue. If there's legislation, I think it's appropriate actually for Congress to weigh in. This all derives, of course, from the 75 Act amendments.
I would point out that certainly if you're going to have an advisory board to a Public Utilities Commission, you include people who represent the consumers, including the very large consumers of the utility services, not just the utilities themselves. Mr. Cherry Seto, there's the bill to change the Form PF to provide some information on the companies. Mr. Himes points out that Form PFs have disclosed certain things about fees. I'll point out, when it comes to Madoff, everything was filed with the SEC and they didn't do anything with it.
Right.
Does it make sense? Our purpose here is to focus, the reason we passed this was to deal with systemic effects, not to protect, although we always want to protect individual investors, and we should have a comprehensive scheme for doing that. Do the prudential regulators need all the information on that form? And is private equity, dealing with private equity, part of dealing with systemic risk?
I think in the case of Form PF, there's definitely additional information in there. Its primary purpose is to look at systematic risk, and that's the lens that one should use to look at the information there. But I'd like to point out, this legislation is not looking to exempt anyone from today reporting Form PF. If this was passed, no advisors would have an exemption from reporting Form PF. This is looking at information, like you mentioned, that is maybe trying to get at the question of systematic risk, and it doesn't serve a purpose for investors. You look at the private market, I would also go back to like the custody rule. Like when we talk about delivering the brochure to our clients, keep in mind that a client in this context is not what was originally meant when they look at delivering to clients. The client is the fund itself. So technically, the bill is saying you need to deliver the brochure to your fund. And when people want to do that, technically follow that rule, they save it on their network because they delivered it to themselves. That's what they're talking about, delivering the brochure. And the brochure is extremely important in this case, and here we're just saying that it should only be updated when there's a material change. If there are material changes, you still need to update your brochure.
Thank you. Mr. Hill is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate you and the ranking member holding this important hearing on these issues. Mr. Quadman, as you know, last October, the Department of Labor released an interpretive bulletin for economically targeted investments and investment strategies, environmental, social, and governance factors, which now allows these factors and collateral benefits to be considered when selecting an investment in a ERISA plan. I've spent kind of 3 decades in the study of and the participation in the asset management industry, and I've read the document, and it's very, very carefully worded, but I still am concerned that this guidance undermines ERISA's mandate that plan assets are invested solely in the interest of plan participants, and that these factors, other factors, might take precedent and deviate from maximizing returns for beneficiaries. In passing ERISTA, Congress chose specifically not to include any provision that would allow plan assets to be used to pursue any societal purpose other than protecting plan assets. To the contrary, Congress included Section 404A, which says, in order to make a law of trust applicable to the plans and eliminate such abuses as self-dealing, imprudent investing, and misappropriation of plan funds. Recently, both of the main proxy advisory firms have partnered with ESG research firms. Glass Lewis announced their partnership with Sustainalytics to integrate Sustainalytics ESG research and ratings into Glass Lewis proxy research and vote management platforms. This is an issue that I don't think's received very much attention, and I'd be interested in your thoughts on the bulletin. Any thoughts and concerns you might have first, and then secondarily, any ties that this to proxy advisors and their advisors that we're discussing today.
Yeah, thank you very much, Congressman Hill. Let me address that in two separate points. We were very concerned about that bulletin. We had written to Secretary Perez before that bulletin was released, where we asked for empirical evidence as to why they were considering some of the changes they were. Unfortunately, with the bulletin today, environmental, social, and governance concerns now rank on par with investment return for ERISA pension funds, and that is now migrating out to other areas. So as an example, the New York State Common Fund, which has an ERISA-type fiduciary duty, issued 75 shareholder proposals last year on proxy access, but they were very open about the fact they were not going for good corporate governance issues. They're actually looking to put a pressure point on companies regarding climate change proposals. So rather than having that open debate there, it was wrapped up in a corporate governance debate. You know, the second point to it is, when you take a look at proxy advisory firms, and this is what the 2014 SEC guidance did and where the Duffy bill goes even further, is that the proxy advisory firm guidance or recommendations need to be correlated to the fiduciary duty of their clients, so of the institutional investor that they're providing recommendations to. So that if we're now beginning to muddy those waters, all the debates that we're having today about enhancing long-term shareholder value are going to go out the water, and we're going to have situations like the Illinois pension funds, where you have a very active pension fund on things other than good return, now suddenly going underwater, and unfortunately it's going to be the taxpayers that are going to foot the bill.
Well, this is concerning to, I think, taxpayers, because public pension funds are severely underfunded in this country, and also use, in my judgment, hypothetical actuarial return statements that are far too high to today's market conditions. So I do have a lot of concerns about it. Commissioner Gallagher, your thoughts on that subject?
Thank you for the question, Congressman. I saw the circular too last October. For me, a similar reaction to what Mr. Quadman said. More though, it for the first time caused me to think about what I see as a trend or a push for the federalization of the retirement system, more generally, where there seems to be interest with ERISA waivers coming out of DOL, this policy statement, and elsewhere, a move towards, as we've seen very publicly, state-sponsored private sector retirement plans, which, if they add an option, if they're in a competitive market, you might think that's a good thing, but I'm not sure that's the case. So I do think this is something for the Congress to watch very carefully, that, the track record of, government oversight of retirement plans has been checkered in some ways, and expanding it might not be the best thing.
Thanks, Commissioner.
Thank you,
Mr. Chairman. I yield back.
All right, Mr. Carney, recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for holding this hearing today, and thank the panelists for coming and for sharing your expertise. I represent the whole state of Delaware. We have a lot of people in my state with considerable interest in and expertise in corporate governance, corporate law, and providing corporate services to 3/4 of the Fortune 500. And I've been involved as a result of that. We have a lot of expertise both in the State Division of Corporation, within the corporate bar in the state of Delaware, as well as in the provision of corporate services. And so I pay attention to some of these issues, and advice that I received from folks back home led me to my involvement with, when we saw the downturn a few years ago and the decline in IPOs, companies doing initial public offering, which led to my involvement with Mr. Fincher in the IPO on-ramp. We're working on beneficial ownership issues today and as we speak. And it's also led me to my involvement with Mr. Duffy when he came to me to talk about this bill, this draft bill that we have here on proxy advisory firms. And so I'd just like to kind of get on the record some of what I think you said earlier, Commissioner Gallagher, about the need for the bill as you see it. In summary, please.
First of all, Congressman, I wanted to thank you for your collegiality during my tenure as a commissioner. Your positive approach to these capital formation issues. It was always great to work with you, even bothering you on the Amtrak train on your commute home. Look, I pushed for years as a commissioner to get some movement, some reform of the proxy advisory oversight system to the extent there was one. The culmination of that was SLB 20 in 2014. I think it was a positive step forward. What I've heard since then, though, it was just simply not enough. And if you look at the legislation that's being debated by this committee, I think it's very incremental in its nature. I think
pretty straightforward. I mean,
it's very straightforward. It gives us, if I'm the SEC again, it gives the SEC the look into this industry, into the conflicts, into the business practices that this Congress 10 years ago gave the SEC with respect to credit rating agencies. And now, unfortunately, that was a little too late in time to stop some of the things we saw in 2005, 6, 7 with credit ratings. But I think that sort of incremental step, that transparency, is hard to argue against. And so I do think, based on everything I hear, there are academic studies that will tell you one thing on the left and one thing on the right. You learn.
Is there something in the bill that you wouldn't do, or something that's not in the bill that you think we ought to think about?
Look, I actually pause, and I've said this to Gary Ratelny at ISS and others. I don't have anything against the industry. If they provide a service and it's good, done in good faith, and it's a good quality product, they should be there in the markets. Where they get the imprimatur of federal regulation, where the no action letters and the rule interpretations basically give them a monopoly, that's something that you shouldn't abide. And so I don't see anything in this legislation because, again, I think you could have gone further. I think it's very incremental in its transparency focus.
Maybe we could talk about those. Mr. Quadman, do you have any more to add to that?
Yeah, let me just add, one, we did a survey with NASDAQ of public companies last summer where we wanted to see how public companies were dealing with the SEC guidance. What we found was when companies were looking for a conflict of interest with the proxy advisory firm, they were finding it 45% of the time. That is a pretty high and dramatic number. And I also have an email. I know Mr. Bartle had mentioned an email, but I have an email here from ISS offering services to a company that was issued after the 2014 guidance was issued, and I'd like to submit this for the record. I mean, I think there are still significant problems that exist. I do agree with Commissioner Gallagher. SLB 20 was an important step forward. I think the Duffy-Carney legislation is a very balanced way to push the ball forward, to have more oversight, to make sure that we have a balanced system that benefits investors and companies, and allows the SEC to do its job.
Thank you. Anyone on the panel have something in the bill that they don't like, or something that they'd like to see us think about in the bill?
Well, Congressman Carney, I was just going to say that I think the one aspect of this bill that can't be emphasized enough is that where there's been this specific oversight, and I go back to the peer group episode in 2012, which got SEC attention, it got press attention, that caused a change, and this ongoing regular oversight will be effective.
Thank you.
So I think that's the positive side of the bill. I don't have anything that I would change at this point.
Thank you.
Hi, yeah, I don't like this bill, and I'm surprised, this is the free enterprise system that we have sophisticated investors that we spoke about before, entering freely into contracts, not required to, with these enterprises that provide an important service for them. And we have regulators who have the tools that they need to deal with both conflicts of interest at the advisory firms as well as fiduciary duty at the institutional investor firms. And purportedly, we're doing this because the regulators can't deal with those issues, and somehow there's a monopoly. If you create this giant complex regime, it's going to create barriers to entry. And secondly, one of the biggest concerns I have with this bill is the private right of action that it gives to issuers if they're not satisfied with the resolution of their complaint when they're given a copy in this very tight, 6-week window to look at the recommendation. And why wouldn't an issuer be unsatisfied if there wasn't a vote the way we want to recommendation? So I'm deeply confused why this committee in particular would be either trying to entrench a monopoly or try to shut down a successful business.
Thank you.
Well, we disagree, but thank you, and I yield back.
Disagree? Okay. Gentleman from Vermont. Oh, no, from Maine.
There are some people.
Thought we had a fellow, but no. It's
Mr. Chairman, there are some people that are envious of not coming from Maine, and I do recognize, and for the record, you're from New Jersey. But I appreciate it very much, Mr. Chair, for this terrific hearing today, and I thank all of the witnesses today. When I was a boy growing up in Maine, our state was dotted with dozens of paper mills, textile mills, shoe factories. And our families could take care of themselves, and they had the option of going right from high school directly into working at these mills with good jobs, with benefits that they could keep and they could take care of their families. You know, over the past 30 years, a lot of these mills have closed. I don't know if you folks have ever experienced it. I have. When a small town loses a mill, it devastates that community. Absolutely devastates it. Schools get smaller, some of them close. The collection baskets at church dwindle. Hospitals struggle. And a lot of families leave and go downstate to New Jersey. That being said, there are a lot of issues that cause these mills to close. Taxes are too high, regulations are too tough, a lot of which are brought on by us, or by the people who set the rules in government. Now, sometimes you can't control it, like foreign competition or different products that are being offered are no longer used, like newsprint or catalogs. Now, one of our great paper mills in the state of Maine, which is healthy, is Twin Rivers Paper, Madawaska. Mr. Cherizito, your firm, Blue Wolf Capital, invested in our mill, in that mill. Now, this is in northern Maine, right against the Canadian border. 600 jobs in the St. John Valley, 600 paychecks, 600 mortgage payments. Thank you, sir, very much for that investment in our state. Now, that mill does not make some of the products that it did, I'm sure, a number of years ago. They make paper bags for McDonald's French fries. I love it. Every time I'm on the road in our district, I go to McDonald's and I buy 2 bags of fries. And they make that thin paper that we print our medication instructions on. Now, I take pills like everybody else, not that pill, and we should continue to print that paper like you do up there. And also the thin paper that our mutual fund reports are printed on. Mr. Cherizito, I'd like to ask you a question. You invested in that mill. That mill was in bankruptcy in 2010. You folks invested in it in 2013. Tell me why you invested in that mill, sir, and tell me what changed at the mill that made it so successful and continues to be a thriving employer in that part of our state. And tell me about the Investment Advisors Modernization Act that Mr. Hurd and Mr. Vargas are putting forward today. Tell me how that can help you and companies like yours invest in paper mills like this and keep those jobs in those communities going.
Thank you, Congressman. I think Twin Rivers is a good example of where there's a company that has a strong reason to exist, but there are challenges that they face that make it difficult to invest. As you had mentioned, they came out of bankruptcy in 2010. There were cuts to the pensions coming out of bankruptcy. There was a lot of animosity and mistrust. People didn't know what the future was going to hold. Coming out of bankruptcy, you find situations where there's liabilities left on the companies that nobody knows for what the certainty of the company surviving. And I think firms like Blue Wolf and other private equity funds in different parts of the market, they come with a certain expertise, and we felt that we could understand the risks of investing in the business and be a partner to help. As you mentioned, it's on the border of Maine and New Brunswick. Part of the company is over on the Canadian side of the border. And you can imagine what the complexities are of coming out of bankruptcy and having both the Maine government and the New Brunswick government involved.
Thank you, Mr. Cherizito. And tell us specifically, how if the Investment Advisors Modernization Act of 2016 offered by this committee would help private equity firms like yours invest in mills like this so we can show compassion for the people that work there and we can grow these businesses and create more jobs.
Sure, Congressman. I think the issue is on focus, right? Investors invest their money with us because they believe that we can find good investments like that, create good jobs like that. And so that's what we do best. I think in some sense it would be analogous to looking at members of Congress and the unfortunate situation where you're asked to spend a lot of time on fundraising. And if you could free up some more time from fundraising, you'd be able to spend more time on what you really want to do here, which is govern and pass legislation. We look at it somewhat the same way for us. Right, here we are, compliance is important, fundraising is important, it's part of who we are, that's not going to go away. But we are successful by focusing on investing money. And so I think in this case, having the legislation be more rational would help us to focus more time on looking for companies and building jobs.
Thank you very much, Mr. Cherizito, again for your company, your investment in our great state. Mr. Chairman, since you picked on my state, I have one more question, and with all due respect,
well, we're going to actually do a second round, I think, here.
My schedule is such that I cannot, but if you can award me another minute or two because of the way you picked on our state, then I would consider it an even fight, and I would consider it we're even, sir, with all due respect.
I will look to Mr. Holgren whether he can hold off for, then, without objection, the gentleman is recognized.
Because Maine is so beautiful.
Thank you. Thank you, Mr. Holgren, I appreciate it. Thank you, Mr. Chairman, very much.
Forewarned never to say anything again.
Yes, sir. I'll talk quickly.
The gentleman is recognized for 1 minute.
Thank
without
you.
objection.
Thank you, sir. Mr. Gallagher, Professor Taub in her written testimony notes that the SEC has the authority to inspect and discipline institutional investors who, quote, and I quote, mindlessly follow advice without considering their fiduciary duty. She further states in her testimony, and I quote, that the status quo is far better than any changes offered by Mr. Duffy. Now, you spent some time at the SEC. Do you agree with her?
Thank you, Congressman, and I love Maine. The professor is correct. The SEC does have that authority to discipline the institutional investors through the anti-fraud provisions. Finding that activity, though, is the real key. There are 11,400 registered investment advisors with the SEC, a couple hundred examiners. So to find evidence of voting abuse that would implicate the proxy advisory firms, you're going to have to send those couple hundred off into the several thousand, as opposed to registering and examining basically two firms that control 97%. So it seems pretty logical that you would take the latter route.
Therefore, I can conclude that you agree that Mr. Duffy's bill has merit?
Beyond that, yes.
Thank you, sir. Thank you, Mr. Chair, very much for the additional time. Thank you, Mr. Holgren, very much.
Thank you. And I think we all agree that we all like the teddy bears that come from, oh wait, that's the other state too. So, Mr. Holgren is recognized.
Thank you, Chairman. Thank you all for being here. Mr. Bartle, I'm going to address my questions to you at first, if that's all right. You note in your testimony that the Center on Executive Compensation is, and I quote, is concerned that the lack of sufficient resources on the part of the proxy advisors leads to a check-the-box mentality, end quote. You also note that the ability to understand and summarize pay programs, for example, requires time, resources, and diligence. You testify, however, that and I again quote you, the irony is that issuers are responsible for ensuring the accuracy of proxy advisory firms' reports, even though proxy advisory firms are supposed to be the experts providing the information that investors rely on to execute a fiduciary duty, end quote. What if you could please explain this irony, as you said, and how can an issuer be tasked with reviewing the accuracy of a proxy advisory vote recommendations?
Well, thank you for the question, Congressman Holgren, and I think the issue is really currently only one firm gives companies that opportunity, and that's in the S&P 500. They often have a very narrow window between 24 and 48 hours, and that's assuming that the draft report goes to the right person at the company, because sometimes it does get lost. For the rest of publicly held companies, they are at the mercy of somebody getting a hold of that and then going back and either dealing with the proxy advisory firm, whether that be ISS or Glass Lewis, or more likely going directly to investors. And if you're a small company, the resources you have to be able to change that within the time you have, because those reports are typically issued within about 3 weeks of the annual meeting. The barriers are extremely high, so the opportunity is fairly small for those those investors, those companies rather.
Okay. Following up, Mr. Bartle, Professor Taub references in her written testimony that an article by Professors Choi, Fish, Kahan, entitled "The Power of Proxy Advisors, Myth or Reality" in 2010, that found a substantial degree of divergence, and I quote, "a substantial degree of divergence from ISS recommendations, refuting the claim that most funds follow ISS blindly," end quote. However, you note in your testimony that several research reports and academic studies have cataloged the influence of proxy advisory firm recommendations on votes on shareholder proposals. I wonder if you could please explain your understanding and the claim that proxy advisory firms are capable of influencing shareholder proposal votes.
Yeah, I think some explanation of this happened earlier too, Congressman Holtman, but I think that if you look at that study, if I recall correctly, the Choi study dealt with non-contested director elections previous to Dodd-Frank. So one, you were dealing with a different subset of votes. Secondly, she was looking at mutual funds with large governance research arms. The research that's out there, both pre-Dodd-Frank and after Dodd-Frank, Bethel Gillen, for example, talked about, I think, a 20% influence of ISS on director elections. The Larker research that talks about significant influence on, say, on pay votes post-Dodd-Frank. There is a lot of research out there. And then, our anecdotal research just from the say on pay votes that shows an influence, definitely an issue. The other thing to keep in mind is influence is different for different investors. The large investors are going to use this information as a bit of a prioritization. Where you get a negative recommendation, their research departments are going to pay more attention typically. That's our experience. For the middle tier, they're going to take the recommendation significantly, and those that, at least for ISS, have ISS vote on their behalf will take it absolutely directly. So, I mean, you're talking about a wide band of investors that are using this for various forms that are influential.
Okay, thanks. Mr. Gallagher, if I can ask a quick question to you. You note in your testimony that recommendations provided by proxy advisory firms may be tainted by conflicts of interest. I wonder if you could provide a scenario where a proxy advisor has a conflict of interest that prevents it from providing independent, objective advice. I wonder if there's any specific examples you might be able to provide.
Thanks for the question, Congressman Holmgren. There are two that really come to mind. One's the more obvious, in which a proxy advisory firm also provides consulting services to an issuer that it's providing recommendations about. And that's one that's, again, obvious, and one that was addressed in SLB 20, which would need to be disclosed, an obvious conflict. Another one that we talked about in the SEC roundtable of December 2013 is less obvious, and maybe one that's more pernicious, which is the control of certain advisory clients over the substance of the recommendations coming from the proxy advisory firms. How do you find that? Where is it in the books and records? How do you prove it? That's a much less obvious question, but it's one that anecdotally I hear exists.
Okay, thank you. My time's expired. Thank you all for being here. Since the chairman has been very kind to the state of Illinois, I will yield back without asking any further questions.
There you go. Thank you. The gentleman yields back. So, without objection, I'm going to suggest to go around for a second round if the panel is up to, obviously there's not that many here, and they all may not use their 5 minutes. And with that, no objection, so ordered. So just a couple, and it's getting even less people apparently. Just a couple of quick questions on the proxy advisors. I'll go to Mr. Bartle. 2 or 3 questions, real quick. In your testimony, that the Center on Executive Compensation conducted a survey that found inaccuracies in the data and facts that the 2 predominant firms relied upon with the recommendations. Can you just briefly explain the findings of the survey again?
Yeah, so the survey, first of all, found that, about 55% of respondents found that they had an error or an accuracy, and about 70% talked about actually, changing a recommendation in advance of a recommendation because of a proxy advisory firm policy or practice in the prior 3 years. So in terms of the errors and inaccuracies, you've got companies that are taking advantage of the research because of this belief, and our study did deal with that as well, because of the belief that there is some influence from the consulting side over to the research side. So you get that fairly regularly.
So I got that. So the issues that these issues have not been just for a short period of time. We've looked at the issue, or the SEC has looked at investment advisors to some extent, and knew that they were out there advised for some period of time. And the SEC took some steps, right? They issued guidance 2 years ago, 2014.
That's right.
Okay. So I guess I'll start with Mr. Bartle. So that guidance comes out, and that's supposed to be dealing with the problem. I guess the short question, very blunt, is has that guidance been sufficient? Have you seen changes in the operations of the firms?
Yeah, we haven't seen changes, Mr. Chairman.
You have or have
we
not?
have not seen changes, Mr. Chairman, and I think the issue is that the guidance reiterated what investors needed to do to monitor proxy advisory firms. It then also said that for investors that are using the proxy advisory firms as a direct, incorporating the recommendations and having them vote the proxies on their behalf, there is a higher level, a higher standard that the proxy advisory firms issue. But when you look at that middle tier that I was talking about, or even the lower tier, the SLB does not impact those. And that's where I think, where we talked about this impact of ongoing oversight, as we saw with, again, I mentioned the peer group issue back in 2012, and we saw it again when, the SLB was issued and the roundtable happened. There is a lot more attention paid to the processes that the advisory firms use because of that attention, and this would elevate that ongoing attention for what Commissioner Gallagher talked about a minute ago.
So, the professor used the word that we don't want to do anything, you said, that would reinforce the monopoly. And I guess actually the correct, or duopoly, but think of it as a monopoly, which is your words. That came about, we do have a monopoly, so you're saying we have a monopoly, and that's, to me, in any framework, is a problem. When you have when there's no, if you're going to have a monopoly, maybe there should be some involvement there for the government to make sure that things are actually running correctly. The monopoly came about not just because of the nature of the marketplace. My understanding, the monopoly came about, somebody said this, maybe Dan Gallagher said this, as far as the no action, I'm sorry, Commissioner Gallagher, came about due to what the no action letter, right? You do the no action letter, that basically gives carte blanche to the firms out there to say, I guess we don't have to do anything. This is my simple way of looking at it. We really don't have that responsibility anymore. No one's going to come back at us. We can just abdicate this responsibility out there, and there's two firms out there, it coalesces around them, and is that, in a nutshell, Mr. Bartle?
Yeah, Mr. Chairman, I think the issue here is that, all of us on the panel, I think at one point or another have said you got to be careful about entrenching the current players. But as a practical matter, the current players haven't changed over the course of the last, 6 or 7 years. And therefore, we view this as a preferable alternative to the status quo because it's got the ongoing approach. The market for proxy advisory firms globally has been condensing, not expanding.
And I'm going to throw one last back on my bill, Professor, to you're a professor, so you have your students, and I'll just throw out this question to you. Don't you advise your students when they're looking and trying to make any of the decisions they have to make, that they should do what? Look at the pros and the cons of that decision. And when you make the look at the pros and cons, basically it's the costs and the benefits of the decisions they have to make in life or in business, and isn't that really simply what we're trying to do?
I'm so glad you said that, because, to be clear, we're not talking about dispensing with cost-benefit analysis. What I'm talking about is what type of cost-benefit analysis should be used, right? Yeah. And secondly, whether it should be subject to judicial review by unelected judges who are not experts in the area. So for example, cost-benefit analysis, should I buy this car or that car, is largely going to be economic concerns and some preferences. Cost-benefit analysis, should I marry my husband, isn't going to be, at least for me, an economic question. It's going to have other factors. And so what we've learned, especially with the D.C. Circuit, when we looked at the D.C. District Court decision and National Association of Manufacturers, they said you can't compare apples to bricks. So I do think that agencies, including the SEC, should engage in a cost-benefit analysis process, and I think it should be of their choosing. It could be conceptual. My problem is the illusion of precision, because it's a catch-22. We say reduce this to a number. We all know it can't be done. Years later, then they can be questioned and mocked for not coming up with the right number.
Mr. Gallagher's comment was they were able to make decisions, not entirely on that, but at least to have that there as a factor. I see my time went way over. I'll yield now to recognize, rather, the gentlelady from New York.
We are talking about all these bills, cost-benefit analysis. I'd just like to reflect a little bit on why did we pass all these regulations? And that was because of the worst financial crisis, certainly in my lifetime. And I'd just like to ask Professor Taub, how much did this, in terms of analysis, how much did this crisis cost the American people? I've heard that everything from 9 million jobs to 9 million people losing their homes. What did this economic crisis cost the American people? How many billions? Trillions, I guess. Trillions.
You know, the actual dollar figures have been estimated in ranges, but in terms of lost economic output, I've heard in the many trillions, and I can't point to a figure. I'm not an economist, and there are many different studies that are out there, but in many trillions. But the problem is, again, it's not just about things that we can quantify. When more than 7 million people, 7 million homes are lost to foreclosure or short sales, that has impacts beyond economic ones. There are also other economic impacts. And the run-up to the crisis, the bubble, the gains of that were not felt evenly, and neither was the crash. And so, the numbers are large, but I don't think we can even still quantify the impact at this point.
Would you generally like to express your belief on how these bills would affect the SEC's ability to oversee and enforce reforms that Congress passed as a result of the financial crisis? Some reported that it was $21 trillion or 13 trillion, a range from 13 trillion to 21 trillion. But many people haven't recovered. Congress put in place reforms to prevent another financial crisis and to better protect Americans from losing their homes, losing their jobs, another economic downturn. I always get reports every now and then that they think the next crisis is on the verge. But do you believe, what about these three bills? Do you think that these bills would prevent the SEC from really overseeing and enforcing reforms that Congress put in place to protect the American economy?
So I think what's ironic about some of these bills is there's some really good tools that the SEC has and information they're given, and these bills want to take that away. But then the third bill, then the proxy advisory bill, wants to foist onto the SEC without any specific designation of which division would handle it and not any earmarked money, a structure that I don't know that the agency, or at least I don't know that investors have asked for or really need.
And like you said, it would take away protections that the SEC has put in place to protect the American economy.
One of the most difficult things is in any cost-benefit analysis, you need inputs and estimations, and you need good data. And there isn't yet good data on the incidence of fraud within firms. That could be banks or it could be other types of firms, and there's not good data on the amount of fraud. So when you look at a cost-benefit analysis, it's not as if we're taking precise numbers, putting them into a computer, and then boom, there's this precise answer. There's lots of estimations and incomplete data. And also these, but again, I think the SEC should engage in economic analysis. All I'm saying is I don't think the problem with adding this on and creating, doesn't eliminate a private cause of action, and even previous iterations of bills might have, but forcing them to go through this particularly quantitative cost-benefit analysis, pretending to be able to reduce something to a bottom-line figure, then becomes evidence in a APA case and so on. It really, it may not, as Commissioner Gallagher says, slow the commission down at the beginning, but it certainly slows them down afterward when they're in court.
Well, thank you, and I yield back the balance of my time.
The Vice Chairman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Gallagher, Professor Taub, in her testimony, makes reference to a report prepared by Better Markets called Setting the Record Straight on Cost-Benefit Analysis and Financial Reform at the SEC. She goes on to state that the organization opines that what sounds like a benign cost-benefit analysis is actually an industry-only analysis. And I was wondering if you could comment on that and whether you agree with that characterization that a cost-benefit analysis is just an industry-only analysis.
Well, thanks for the question, Congressman. I'm not familiar with the Better Markets reports. I don't spend time with special interest group reports like that because they're typically one-sided on their own. And so, I think this all just boils down to, as I mentioned earlier, just good government. And, we have a disparate body of congressional mandates that the D.C. Circuit has interpreted to require the SEC to conduct an economic analysis today. I think what you are doing, what Chairman Garrett is doing with his bill is tying it all together and making it clear, making it followable and predictable. It doesn't mean, Professor Taub may be absolutely right, that it changes a posture in a litigation that follows a rulemaking, but I don't think it's necessarily for the worse. I think it's such a bowl of spaghetti right now that it's incumbent upon Congress to clarify it.
Thank you, and I yield back the balance of my time.
Gentleman yields back, and gentleman from California is recognized.
Well, thank you very much, Mr. Chairman. Appreciate it. And I had a question for Mr. Quadman. You note in your written testimony that rule-writing entities, such as the PCAOB and Municipal Securities Rulemaking Board, are subject to the same requirements and enhancements contained in the SEC Regulatory Accountability Act. Could you please explain why that is beneficial? And also, should the SEC require FASB conduct similar cost-benefit analysis when setting accounting and reporting standards?
Yeah, thank you, Mr. Royce. So first off, for any, we propose for any subordinate organization of the SEC that if they're involved in rule writing that has the force of regulation, there should be a cost-benefit analysis. So that would include FASB. I believe FINRA has committed to do that. The PCAOB, as an example, their standards have to go through the SEC rulemaking process before they go final, so you should have a cost-benefit analysis there. And, as one example, just through the PCAOB, because they could not get standards done over the last several years for a variety of different reasons, had a very aggressive inspections program. And because that very aggressive inspections program, 2 years down the line, companies suddenly started to see that their internal control costs were going up by 300%. So that shows, number one, the dramatic impact the PCAOB could have on companies, but more importantly, why you need to have actions go through a formal process so you can understand what the costs and benefits are rather than through a circular route.
So that's one of my concerns. Let me go to a question of Mr. Bartle. I'm struck by the inherent conflict of interest that you described in your testimony when the ISS consulting arm uses its relationship with ISS research to sell business. Is this a common occurrence, I'd ask, and do investment advisors take this into account when hiring a proxy advisory firm, and should they?
Thank you, Congressman Royce. I appreciate the question. And so I think the answer is we've seen a much more aggressive push by the consulting arm of ISS against the research side. The one email exchange that we included in our testimony is just an example. In fact, the irony is that one was actually repeated to another company using the wrong company's ticker in rapid-fire succession. I think what we have seen is that there are certain types of investors, pension funds particularly, that have a tendency to use Glass Lewis because of the lack of consulting arm there, even though there are other conflicts inherent in Glass Lewis, as we talk about in our testimony. And so I think there is a knowledge. In fact, when Glass Lewis came on the scene back in around 2002, that was one of the things that led to that occurrence. But both proxy advisors suffer from, conflicts of interest that certainly deserve greater oversight and scrutiny, and that's I think one of the redeeming factors, one of the best reasons for Congressman Duffy's bill.
And Mr. Gallagher, so you're saying that's that added transparency Mr. Bartle was saying, or knowing a conflict exists, is part of the solution here. Your thoughts quickly on how Mr. Duffy's bill helps get at that problem?
Thank you for the question, Congressman. Look, I think it gets right to the heart of the matter with transparency and disclosure, the basic tenets of the federal securities laws. If there are conflicts, disclose them. If there are conflicts that Congress can't abide, you might want to prohibit them. And that has happened, too, in other scenarios. But just the basic knowledge and disclosure of these conflicts can help investors and voters make better decisions, and we don't have that.
Maybe, but I think there's more that has to be done here, because there should be more competition in the proxy advisory space. But instead, what we've created is a government-approved duopoly that is not serving investors. You go back to Mr. Bartle's testimony, where he said we now have a check-the-box mentality with little review of the accuracy of proxy advisory firm reports. What could be done to change this dynamic to really introduce competition, given the duopoly?
In addition to the legislation that's being debated here, I think the SEC could rescind the 2 no-action letters that followed the 2003 rulemaking that basically created that duopoly for the 2 firms. And I think after that, I'll tell you, Congressman, one positive thing is, a lot of this is couched in the negative. Since SLB 20, we have seen the advisor community pay more attention to these issues. We've seen the larger asset managers resource their voting function. We see the message trickling down to medium and small size advisors that A, you don't have to vote every share, every vote, that B, you can do things other than rotely relying. But I take Mr. Bartle and Mr. Quadman's word, on its face that this still isn't enough.
Well, in closing, I thank the chairman for holding this hearing, and I certainly want to thank my colleague for the legislation that he's putting forward here. Thank you, Mr. Duffy. Mr. Chairman, thank you.
Thank you, and with that, I will yield now 5 minutes to sponsor legislation. Mr. Duffy.
Thank you, Mr. Chairman. I apologize. I had to step out for a little bit. Rarely have I been in this committee and been advocating for more regulation. This is, I think, a first for me. So duly noted. Mr. Bartle, just again, I think you've had several questions about conflicts of interest in regard to proxy advisors. Kind of lay that out for me again. You did it in your testimony, but lay out conflicts of interest in regard to proxy advice.
Sure. I mean, they're really, and really appreciate the bill and the question. There are really 3 or 4, depending on how you slice it. One is the role of ISS in providing consulting to companies, and on the other side, providing research that's so-called independent. And this firewall that so-called firewall that exists
doesn't exist.
Right. Well, and that's, again, why oversight is necessary. Probably even more importantly is this notion of providing consulting on shareholder proposals by investors, investor proponents, and providing cursory disclosure on the fact that they do so, because they then provide recommendations on those same proposals. And, hopefully...
So in fact, you could be given advice on a shareholder proposal, and then to other investors how they're going to vote on their proposal, and to the company in which it's affected.
That's correct.
And does this go to the highest bidder? I mean, if you pay the most money, You win the day?
Well, and again, we've got the separation that's there, but this is, of the issues that probably have the most impact, that is probably the one. And then you have, beyond the operational side, the ownership side, which is on the Glass Lewis front, its ownership by the Ontario Teachers Pension Plan, both private equity and...
Do they give advice on companies in which they invest?
They disclose the fact that they are giving advice on companies in which OTTP exists, or OTPP.
Does the panel all agree that this is a problem, that there's a conflict of interest here?
Yes, Mr. Duffy,
yes.
I agree with Mr. Bartle's characterization. I would also just add, too, Glass Lewis, they're owned by an activist investor fund. And we had actually written twice to the SEC in 2011 and 2012 asking them to look into the apparent, or at least the appearance of a conflict of interest with activities by the Ontario Teachers Pension Fund and also Glass Lewis recommendations as well.
So we're looking at a lot of companies and a lot of shares. Do these proxy advisory firms have the staff to provide adequate advice, Mr. Quadman?
As I mentioned earlier, you have one firm that has 180 analysts looking at tens of thousands of companies globally, making recommendations on 250,000 shareholder proposals and director elections over a very compressed time period. And you would just have to look at that as you can't possibly do the due diligence that you need to do. The other thing is, I mean, as others have mentioned here, there's an extremely high error rate. And, I have to say, Mr. Ritelny at ISS has made some changes over the last year where they're starting to issue new reports where there's an error that's been found and fixed. But even before that was done, I mean, that was not done up until about a year ago.
So the answer is they don't have the staffs, right? I mean, they're not big enough. Mr. Gallagher.
Yes,
go ahead.
That question, anecdotally, I hear they do not. But again, everything I've heard is just an anecdote. I haven't gone to the physical plant. They're not SEC registrants other than the Registered Investment Advisor subsidiary of ISS.
So you had a different chair in the not-too-distant past at the SEC. Is it your opinion that the SEC can act without legislation, or do you think that we have to have legislation here to instruct the SEC to act on this issue?
So this is the metaphysical question I've been wrestling with for years, because I was trying to get the SEC to act in a manner that would obviate legislation. I think the SLB 20 was a step forward. Rescinding the no action letters, revisiting the 2003 rulemaking and the interpretations thereof would have been other positive steps, but they were not taken. But to tell you the truth, at the end of the day, even if all of that had been done, you'd probably be sitting here today debating legislation.
And do we agree this has a huge impact on corporate governance? That you have two firms that control 97% of proxy advice?
Absolutely.
In two firms?
Yes.
And so it would be incumbent upon us to actually take action, instruct the SEC to make rules, and let's get this taken care of. Anyone disagree with that?
No.
I do. I think I'm not an antitrust expert, and I don't recall.
Your time is up. No, if I could have 1 minute, and if you can answer the question, we're almost.
If she says she's going to agree.
That's right.
I don't want to take your time, but
I'm sorry. It was. You have the additional minute to respond.
I'm sure the ranking member wouldn't oppose either.
Thank you. I mean, I don't recall referring to the two companies as a monopoly. I think I was referencing something someone else had said. But in terms of this, if you're concerned about two firms having a larger share, having the majority of the 90+% share of the market, then I don't see how creating a more complex regulatory regime that would possibly create barriers to entry solves that particular problem. Also, I'm hearing two different things. I'm hearing folks say, we need more people doing this, and then I'm also hearing it's not possible to be done. But what is the status quo if these firms don't exist? Large institutional investors are choosing to rely on them as one data point. Smaller investors rely on them. What would happen to small investment funds? Would they have to create duplicative in-house proxy voting staffs that were going to read all of these all these proxies? There's nothing wrong with going to a third party and getting investment advice. As for the conflicts of interest, let me just say, other fields there's conflicts of interest, and how are they dealt with, whether it's law or finance? The first step is disclosure. And if we look not just...
You agree with disclosure, right?
I agree with
disclose something.
disclosure, and I also agree with the first step is best practices. And if you look at what's happening in Europe, you look in the U.S., Glass Lewis and others.
And I want to give Mr. Gallagher a chance. Are you a lawyer?
Yes, I am.
As am I. It was pretty tough. I never could represent two clients in the same case. There's a conflict of interest. Invariably, they have competing interests, and you can't represent both of them aggressively, and that's why we say, listen, you got to pick one. Mr. Gallagher, want to quickly respond? Do you agree with Professor?
Yeah, I agree on that conflict analysis, and I just want to point out that there are two big things that came out of SLB 20. It was clarification from the commission to the advisory community that despite what you read into the 2003 rulemaking, this wasn't the Department of Labor, this wasn't the Avon letter, you don't have to vote every share, every vote. Well, that's still not going to be appetizing to most advisors. They're going to feel they need to vote. The second part was that we said you can predetermine your voting. You can tell your clients, your advisory clients, we're going to vote with management every time. You can tell them we're going to vote with CalPERS every time. It can suit your fiduciary duty, as Mr. Bartle said earlier. We haven't seen that take up. That would obviate the necessary reliance on ISS and Glass Lewis. We haven't seen it yet. So,
as always, great point, Mr. Gallagher. Fantastic panel. Thank you for all of your agreement. With that, I yield back.
Thank you. The gentleman yields back. I will concur. Great panel. Thank you for your input and your information. And with that, Chair notes that some members may have additional questions for the panel, which they may, as always, submit in writing to the panel. Without objection, the hearing record will remain open for another 5 legislative days, in which time for the members to submit those written questions to the witnesses and to place their responses then in writing on the record. And also, without objection, members will have 5 legislative days as well to submit extraneous materials to the chair for inclusion in the record. And with that being said, thank you again, and this hearing is adjourned.